I'm going to go ahead and get started. My name is Dan Quigley. I am Senior Vice President here at Kirkpatrick Management Company. What I do is I run the operations for all of the association divisions. So anything that anybody you'll talk to in this office as far as accounting, customer service reps, managers, regional managers, things like that. That's who I talk with every day. That's my job is to make their hopefully make their life a little easier and make your life a little easier. So that is my job. I am going to start off by giving you my phone number, my cell number. My cell number is 317-847-0016. The idea with that is if you can't find your CAM, you can't find somebody in this office, or you're not getting what you want out of Kirkpatrick Management Company, call me, text me. You pay for my cell phone. My cell phone is a company cell phone. You guys pay for it. So it is your cell number. As board members, please don't give it out to your homeowners. I think you can understand why that's not a great idea. But as board members, if you can't get a hold of your CAM, first choice would be the CAM. Second choice is going to be your regional manager. Find me. I will be. I'll figure out something to do. I can solve emergencies with the best of them. So get to me if you need me, or if you just have a question that you just need a little higher answer on. I'm your man. Kirkpatrick Management Company is celebrating its 52nd year this year. Rob Kirkpatrick has been the owner since for 32 of those years. He bought it from his father, who started in 1973. We still have two of the same associations that we started with, the same two associations we started with. We are still working with Roxbury Terrace here in Indianapolis, and also Three Fountains Cooperative on the cooperative side. It's a family business. There are still seven Kirkpatricks that work in the office every day, all day around here, and it's very much a great place to work for us, and hopefully a great place for you guys to do business. It's an interesting business in that it's a second career for everybody. Nobody grows up and wants to be a property manager. But we have a lot of different people that work here from a lot of different backgrounds. We've had bail bondsmen, we've had a couple Orkin men, we've had some different things. People come from all over and have different areas. We bring them in, talk to them about being association property managers, customer service reps, accounting, and it seems to work. The last 7 years in a row, we have won Best Workplace from Indy Star. And so we're pretty proud of that. So we try to make sure you see your people work pretty hard. We work a lot of nights, we work a lot of weekends, but we try to make their life a little bit easier. But we have two offices. If you guys don't know that, we have the one here in Castleton area, which is around 71st and Binford Boulevard. That's our headquarters, and we also have a very similar office. It's just a little bit smaller down in Greenwood, at 400 Canby Street, that has just the same amount of people. We mostly deal with any associations south of I-70 down in our Greenwood office. I'm going to go ahead and introduce your speakers for today. It's sad to say that Tammy from the villages, Cape Cod Villages, and also the Cape Cod Duals board president, had a little bit of a voice problem today. She will not be able to join us, and so I appreciate her trying to do that. It was funny. She emailed me, said she couldn't make it because she lost her voice. I promptly picked up the phone and tried to call her. I don't know what I thought I was going to get, but she could not make it today. And so we're going to have two of the people we got Jake Lawrence from he is a partner at Eads Murray and Pugh, which a lot of the people on a lot of your board members on here work with Eads Murray and Pugh. He did his undergrad at IU Bloomington and got his law degree from Charlotte School of Law. He has been with Eads Murray and Pugh about 7 years. He is a no nonsense um, um, uh, lawyer. He's going to give you the answer that he feels is correct, and it doesn't. He's not going to try and make friends and try and be happy. Make everybody happy. Not everybody's happy in law, right, Jake? They just doesn't happen that way. Yeah. Debbie Krager has been with Kirkpatrick for about 7 years. She's been in property management for over 10 years. She's got her she's kind of the leader around here in initials after her name. She's got a couple initials. I don't know what they are. I do know she has an MBA from the University of Iowa. And she's also got her just this year got her PCAM, which is the highest association management accreditation you can get from the CAI. So you're in great hands today. Debbie and Jake will walk you through. If you have questions during this presentation, you'll see on the bottom of the screen there, where's my hand on the screen? Bottom of the screen, there's a Q&A box. put your questions in there. I will try and answer the questions if I can. If not, I'll kind of hold them and we'll answer them live if I can ask Jake or Debbie to do that. That's about it. That's my 5 minutes. I will talk to you possibly at the end, but we're going to try and go through here at the end of all of this. We will open it up for some questions. One of the things we do want to make sure is, everybody's documents are a little bit differently. So the practical tips are going to be very broad, I believe. And Jake will tell you that if you ask about, something too specific, he'll be able to tell you that that's something, maybe talk to offline or talk to your attorney if it's not East Marine Pew and get you some more information. But this is just going to be a great overview, and it's going to really help as far as knowing what to look for on your documents and how to look at them. So, Debbie, Jake, thank you very much. I'll hand it over to you.
Thank you.
Sorry, it's not. There we go. Okay, thank you for coming today. I just wanted to give a little shout out to Jake. I've worked with him for several years, and he's my go-to as well as EMP. So Jake and I've had some very interesting conversations over the years, but always very good, helpful for information. Today, I'm going to be using some examples, but not mentioning the particular contract, the HOA. I will be using that because they have things that have happened in their communities that are relevant to things that you've probably experienced. So if you have, like he said, please be sure to hit the chat button. We're going to talk about the documents that are most relevant. First of all, we're going to talk of the bylaws. This is basically how the organization, how they organized initially by the developer and or builder. Sometimes you'll see in your documents the word declarant. That is the builder. The CCRs is how things actually run. So it's the practical items you're going to want to review because it's going to apply to all the things that go on in your community. There's legal changes, there's the bylaws changes, and TCR changes, and they have different processes. Then we're going to go into resolutions, which is the next level for reports and changes. This is done by the boards, and Jake will talk about more. And then there's policies. These are things that not totally addressed in the HOA documents, but they're common things that you have to deal with in your communities. The biggest one we have coming up soon is the annual meetings. Annual meetings have some very specific topics and action items that you have to meet. First of all, is when is it? It's very important to know that even if your meeting might be in November, you should start planning at least 60 days ahead of time to put all that information together. For example, a notice that says in the documents, 14 days. Well, you can't use 14 days as to when you action, because you have to account for at least 5 days to get the notice reviewed by the KMC as well as the board. Then it has to go to the mailing system, which can be 3 days, and then the postal service. So all that kind of stuff is pretty variable. So we push to get that information out 30 days in. If it's a community that has 30 days notice, then you want at least 45. That's really important. One of the things we do is we will use a save the date e-blast, so at least people know when the date's going to be, and it tells them more information is coming. You will see in your bylaws, it tells you what the agenda is. A lot of times boards want to use more presentation style, not following to the agenda, and Jake will talk about the implications for that, how you handle it. The other part is quorum, because there's quorum of how many people need to be there to be able to vote in most cases. When it comes to nominations and voting, nominations are often in the floor, or ideally it's in advance. And the reason you want to advance is so you can do your ballots and have them printed to ease counting of them at the meeting. Who does the counting is also something the board wants to consider. Sometimes KMC will do the counting, and sometimes it'll be a board member or a volunteer in the community. Everybody kind of does it differently. The floor, when people put it on the floor, I somewhat question the motivation, because if you don't know until that day that you want to be on the board, the question is why. One situation was a person that wanted to run said, I want to wait till the to the meeting on the floor because I want to make sure I don't work with anybody that thinks the way I do. So go to motivation. Sometimes you have to ask that. The board, there's steps to that. First of all, there's the turnover. When you have the turnover is when the declarant gives it to you, the builder. During that, you will see in the bylaws, it will say the first meeting is 3, 2, and 1 terms. Often people confuse that with all the time you have to 3, 2, 1. Now, once you go through the 3, 2, 1, then it's ongoing with the term that's in there. Often it's 2, sometimes it's 1, sometimes it's 3. I've never seen anything more than 3. There's also a difference between a director and an officer. Everybody's a director, and officers are directors that have a position like a president or a treasurer. Then there's people that are appointed. If a board member leaves or out of the community or decides it's not good for them, the board can appoint somebody. They don't necessarily have to. It depends on the HOA documents. And then the powers. One of the biggest things that comes to the powers is who approves the budget. That's a big thing because it can impact how you pick up the date you set for your annual meeting. For example, if the owners have to vote on the fee, then you need to do that at least 2 months in advance for your meeting. And often you'll see the conflict in the HOA documents and the practical application, but that's something that hopefully Jake can cover. Okay, Jake, it's all you.
All right, thank you so much. So again, my name is Jake Lawrence, partner with Eastman and Pugh. Like Dan said, Debbie's right. We've been involved with some crazy things, but that's it's the nature of the beast when it comes to this, right? I came from family law, and if you thought divorces were crazy, try messing with people's property. But at the same time, going into basically the bylaws as far as types of meetings, legal limitations regarding that. So piggybacking on what Debbie said, right? There's a lot of different nuances when it comes to your meetings, especially annual meetings, special meetings, board meetings, right? Those are the 3 main types of meetings. Your annual meeting, clearly open to everybody. All right, that's the one you have each year. Debbie's exactly right. You want to make sure you're allowing a wide berth as far as the notice is concerned, because you want to make sure, one, you're getting as many people there as possible, right? We all know, we've all been there as far as trying to corral your members and make them care, right? Clearly, you guys care. You're here. But we all have those associations, and we all know those associations where, hey, we got the same 15 people that show up to every single meeting. How do we get more people? Well, big part of it is notice, right? They need to know. As long, some of you may be a little overzealous, which, hey, that's fantastic. So we have to look at the association documents, and then there's usually a nice window, right? There's that 14 days that Debbie was talking about. A lot of times it will say no more than so much time too. So you'll see 60 days, right? So you can't give somebody notice of a meeting in December in June, right? As much as you would like to. Now, that doesn't say that you can't send a save the date. The official notice, though, needs to go out within that window. And that's where KMC does an amazing job as far as the e-blasts and keeping everybody in the loop so that you see what's coming down the road, right? You see what's going to be out there. As far as the limitations regarding regarding budgeting and things like that, Debbie's right. That's usually the biggest issue. That and the elections, right, are the biggest issues that you're dealing with in an annual meeting. And so if your association was formed post 2009, which is when the HOA Act, which again I'll talk a lot about here, the Indiana HOA Act took effect, you're required to at that point have an approval of your budget. If it's prior to 2009, it is completely document dependent as far as who approves the budget, meaning that many associations prior to 2009 are set up so that the board is the one that actually sets the budget themselves, and they have to, but there's requirements for them presenting it and obviously providing that information to the community so that questions can be asked and that the appropriate due diligence is shown to have been done. As far as quorum is concerned, this is a question we get a lot, right? Let's say your quorum is 50%, and that's in your bylaws. And we'll talk about amending bylaws in a bit, but let's say your quorum's 50% of all homeowners involved. That means per lot, right? That doesn't mean that, Jenny and Jason, who are married, count as two people. No, they live at the same they live at the same place. They count as basically one vote. So it's all voting members, meaning all votes. If you have a very high quorum, it can be difficult to meet, right? And again, like I said, we'll talk about this in amending. It may be smart to look at potentially trying to lower that so you can get business done. Because what occurs is this: if you don't meet your quorum, no official actions can be taken. What happens a lot of times is that, hey, we've sent out the notice, we've done everything we possibly can do. We don't have an electronic notice, or we don't have an electronic voting provision. We don't have certain things that basically make it far easier on us. We have pretty archaic documents that say you have to have this many people here. Well, you don't meet that. Guess what happens? You now have an informational session instead of an official meeting. And what happens there is that an election can't take place. The budget can't be voted on because no official action can be taken place. It can take place. Many times what you will see though is you will see a provision within those documents that says something to the effect of a subsequent meeting can be held within 30 to 60 days following that meeting if quorum is not met. And notice can be resent out, but notice is sufficient if it's provided at that meeting. And sometimes you will also see that the quorum amount can be halved or cut by 50% there as far as that's concerned for the next meeting. So if you have a 50% quorum, like we talked about, then it drops for that subsequent meeting to 25%. Again, not trying to get into the weeds, but there's ways around a lot of things if your documents allow for them. And those are going to be specific questions that we can address with you.
Jake,
Biggest
I
issue
do
that
have,
you want to look at, worst case scenario, you don't meet quorum, your board stays in place and your budget is the same as it was the year before, right? And that's what occurs. So if you don't have to approve the budget, hey, that's great. That means you only have an election that has to happen, and your board is going to stay in place until such time as the next annual meeting or somebody drops off and they reappoint, right? So that's what you're looking at. As far as AI for minutes,
Jake, real
yeah,
quick, I do have an election question.
yeah.
Bill Fleming from Steinmeier asked if you get a nomination from the floor at the annual meeting, do you have to vote on that nomination at the annual meeting, or can the board vet the nomination first and then decide if they are board qualified?
Thank you. That's a great question. So really, it's really dependent on the governing documents as far as that's concerned. So if you have somebody that is, let's say your governing documents state that nobody that is not in good standing, meaning they're delinquent or they have an active covenant violation. Again, this is controlled by your documents. If that person is one of those people that says, "Hey, I want to be on the board," and that goes to motivations that Debbie was saying, at that point you can say, well, we're not going to accept that nomination because of that fact. But you want to make sure that you have that information readily available prior to. So you want to make sure you have delinquencies and covenant violations in a list prior to, which I know KMC does, in order to be able to sign in anyway. Now, if those limitations are not there and you don't have a restriction on floor nominations, meaning that you don't have something in your governing documents that provides that nominations have to be received prior to, and a floor nomination is only available if you don't have the requisite amount of people that are nominated. At that point, you're not really able to stop somebody from nominating themselves, or being nominated. It's, again, very document dependent on that. So hopefully that answers that question.
Yep. Thank you, Jake.
Yeah. So AI is a scary area, right? I at least for me, in my opinion, I think there's a lot of great things about it, but there's a lot of very scary things about it. So for minutes are something, again, they shouldn't be super, super, super detailed, right? But they also can't be just, hey, this person spoke, right? It has to be Debbie Krieger spoke about the types of meetings involved, right? That's a meeting minute right there, right? That's a good meeting minute. You want to be careful anytime anything's recorded, right? What we normally say is, and again, disclaimer, don't take this as legal advice, but the general advice is that you do not record a meeting unless you absolutely have to. And if you have to, it's only for the purpose of taking meeting minutes. And then that recording is destroyed immediately after those meeting minutes are taken or are written down. So that would go into AI and the fact that AI is going to take everything, right? They're going to record absolutely everything. So you need to review to make sure that there is no protected information that has been put within that. As far as homeowner questions, you want to put that in an agenda that if you're going through your agenda, you only have a certain amount of time. Make sure you're hitting these points and you're getting through your meeting. It's the board president's usually their responsibility to run the meeting. Run the meeting in an efficient manner. And if you have questions that continue to go, save them for the end. Put it at new business, whatever you need to do to keep things moving. If it's a super important issue that you know prior to that you're going to get a bunch of questions on, put it on the agenda. Let's say there's a pond issue that's happening. Put it on the agenda. Say we're going to take as its own separate line item at the end so you can get through the major business and then you can save it at the end. Notice, again, we talked a little bit about it already, and the HOA Act is going to control, so will the Condo Act, depending on if you're a condominium or a standalone homeowners association. And then you have the Nonprofit Corporations Act, because each one of you are a nonprofit corporation and under Indiana law. So those are the things, the three main laws that are going to control when it comes to an association. Again, notice, be careful. It's document specific as far as whether or not you're allowed to use electronic means for the notices, or you have to go back to old school snail mail, and you can update those provisions in your bylaws depending on when we get to the amendment provision. Next.
We had a question. Charles had a question about what about a Zoom recording? And I don't know. I might ask him. Charles, can you expand a little bit on that? Let me see if I find you on here. What do you mean by a Zoom recording, if you don't mind?
All of our board meetings, we do Zoom for our homeowners and board members that can't be there, and it is recorded and we keep a copy of it. So he's talking about recording, don't record. We record the whole dad burn meeting.
So you want to be careful with that, especially a board meeting, because there are certain portions of your meeting, especially when it comes to a board meeting, that are meant to be what's called an executive session. They're not meant to be provided to the rest of the community, right? Or something that is discoverable to the rest of the community. The problem becomes, Mr. Woodard, that if you end up, let's say you record that meeting and you think, well, nobody's going to get this because you have to be on the board. Well, there's always a possibility that is leaked somehow, some way, and then you have potential for liability. Hence why what you want to do is if you're recording your Zoom meetings or your board meetings, again, you're taking minutes of them and then destroying that recording because of the fact that you always want to make sure that the best way to state it is that if you legally don't have to do it, don't do it.
Okay.
Do what is legally required, and that is it.
Our meetings are Zoom, of course. I mean, that's what I'm saying. We have in person, we have homeowners that can come to it. So it's open to the homeowners, it's open to the public. And our meetings are on Zoom. They are recorded. Those are posted to our website. We do not record our executive session. If we go into executive session, which is at the end of our meetings, we have everybody leave and it's strictly the board members. And we do not record that. That's not on Zoom or anything. But
Okay.
Our meetings are Zoom, and the meetings are actually posted to our website, and they can go in and look at the meeting at a later date if they want to. And
I mean, that'll help things a lot. Again, if you're not recording the executive session part of it, that changes the equation a bit. I will still say the only thing that I would caution you on is, again, you still have to take minutes, obviously, right? I'm not saying that you don't have to do that. That's something to still consider, that the recording itself does not discount the requirement under the Nonprofit Act and HOA Act to take minutes. You still have to have written minutes. But just I would caution you based on litigation that I've dealt with where statements have been used against certain people. So just again, if that's a practice that you have, I applaud your transparency. Just be very careful from a liability standpoint.
And
Thank-
since we're doing this, can I ask a second question to this?
Oh, Charles, you're killing me here. Go
I'm
ahead.
sorry. Just it is kind of important. I think everybody would like to know. So
All right, go ahead. No, go
we
ahead.
do this, and part of the reason for Zoom is because we have board members that can't physically attend the meeting, maybe. But my question is, which we've argued back and forth, and we allow those board members that can't attend, because if they're on Zoom, they're allowed to still be able to vote. But the problem is we've had problems with voting by proxy if you're not able to be at the meeting, or people don't like the fact that a board member can vote by Zoom. What is your thoughts on that for me, sir?
Well, my thoughts on that are that the way a meeting is defined as a meeting is when anybody is able to be there simultaneously, basically, and they can be heard and speak. So just like a Zoom meeting, a conference call is the same way, right? That constitutes a meeting. So there's actually been, not to get too much into it, there if you're having a conversation with a few of the board members, let's say over a beer in your driveway, there's literally been case law that states that can constitute a meeting. So you need to be careful about it, but at the same time, yeah, you have the ability to hold meetings, as long as the notice is properly provided and things like that. You have the ability to hold an electronic meeting, and that the board has the ability to vote as far as in there if they can participate in real time, which is what they're doing, right? Saying I over the phone or whatever it would be, they have the ability to do so. So, and again, that's where the meeting minutes come from. A big part of it is that you record. That's how you record those votes, right? So that you have the ability to do that. People may not like it, but you know what? Again, as Dan said at the beginning, I'm not going to tell you what you can and can't do as far based on what somebody else likes and doesn't like. Too bad. If your homeowners don't like it, move.
Okay,
right.
I like your attitude. Thanks,
Yeah,
Dan.
Charles, he's your kind of guy, Charles. I can tell you that. All right, I'm going to mute you, Charles. Let him get back to it. Thank you.
Okay.
Go ahead. Thank you,
Okay.
Jake.
We talked a little bit about the budget. There's a couple more things I want to go with that. In most documents, you will see that the budget and or any changes to the fee has to be delivered to the owners 30 days ahead of any change. That is really important, and again goes to when you set the date for your meetings. That is one of the areas that you can get in trouble if you don't plan ahead. And you'll find that we will reach out to you and say, hey, you're running really close to this, this limit, so be careful. And also, like Jake mentioned, sometimes you don't have everybody there. In some of the HOA documents, you will see if the owners don't approve the limit you're going, for example, say you want 8%, there's often a clause in there that says, okay, the board can do up to 4%. So I always encourage boards to, if you can, keep that budget under that number, because it just saves the extra efforts of having to increases. And the other part is the risk of underfunding. People don't want to increase dues because it's too expensive, people will say. Well, I have a community that I worked with, and they did not do that for years. And then eventually the buildings were falling apart, and they had to do a major assessment, which included a loan from the HOA fees and to the individual owner. You can't afford to waste and look your hand in the face and not recognize their risks. Signing contracts. Oftentimes you'll get a proposal from a vendor, and it's a proposal. and there's no terms, there's no warranty, there's no cost for termination, and that can be really risky. So I always current my people to please, if it's 20,000 or whatever the number, or it's involves something that's very risky, like electrical work, you want to have an attorney review it. You'll find that once you get that and you give that as addendum, Greg Chandler with EMP does that for the communities I have, you'll find out how many vendors go, oh, I don't have a termination, I have to provide warranties. And then you have to ask yourself, well, is this the kind of vendor I really want to work with? And then we go into the ARC or ACC process. In most documents, the CCRs, you will see the description of ACCs and approvals. Usually it says at 30 days, it's either deemed approved or denied if you don't get a response back from the board. That's really important that boards recognize that. Because if it automatically goes approved and it was for a fence that is not to the CCRs, you have a problem. And you got to make sure the owners know too that the clock does not start until all their documents are in. Usually the biggest problem is getting the plat or survey. And then there's the consistency of application. We get this most often with fences. Somebody sees, well, my neighbor has a 6 foot, even though you say I can only do a 4% or 4 foot. Hopefully Jake can discuss that, because you have to treat people the same, but at the same point, how do you apply it if it was done in the past? So that's one of the things that gets to be a little dicey with ACCs. You also have the situation where there's committees that do the work. Committees can approve it, but the board has to sign off on it, because they are not people with the powers to do that enforcement. So when I talked about some of the things in the rules of regs, and which is a section in the CCRs, that's usually stuff like you can't have playground that's wood, or signs can't be in the yards, that have to be in their windows. Those are the kind of things that are typical. A lot of those things are standard, like nuisance, smells, loud noise, those kind of things. So, Jake, it's for you.
Yeah, thank you. So just to touch basically on sorry, go ahead.
Real quick, we'll go backwards. Debbie, could you, Dennis, the clerk was asking, could you kind of describe ARC, ACC stand for? What are you talking about on that?
It's a term that's either how they put it in the documents, or more of a practical use. It means architectural request committee, or architectural standards. It's just a word
Control
that's more
committee, yeah.
practical in nature.
Most of it is totally dealing with architecture, Dennis. So we should be able to. That's what we're looking at. We probably all call it something different. So sorry about that. Go ahead, Jake. Thank you.
Yeah, not a problem. So the important thing with and again, I want to touch on, just because Debbie kind of asked me to step in there as far as uniformity on enforcement, and it'll go to obviously this portion. That's literally the main crux of what I do at EMP. I'm our litigation specialist, and I the majority of litigation comes from enforcement. So hence why I'm probably as brash as I am. But at the same time, where you're at is there's processes involved with enforcement, and that's controlled by both the Condo Act and the HOA Act. It's very basically the exact same procedure that's put out. Is called a grievance resolution procedure, and that's what has to be followed in order to enforce. Right? There's not the ability to fine people in Indiana currently based on the state law. So if somebody leaves their trash can out, you can't say, well, I'm going to charge $50 a day until you pull that trash can in. Like other states, which, man, that would make it way easier if we could do that. Here, we're not able to do that. Even if it says it in your governing documents, the hierarchy of documents, meaning basically the law itself, will trump that, and we won't be able to collect on that. But what we have to do is we have to send violation letters, right? Which KMC will usually send the first few violation notices. Then if it continues to escalate or that just exist, they'll turn it over to our office or whatever attorney's office you're using, and we'll have to follow that process as far as to provide that notice, provide the opportunity for a meeting, which again, it's a good faith resolution, basically a settlement conference that can be requested. And if if the parties can't come to an agreement at that point in time, impasse is reached, and then we can file a lawsuit to force compliance as far as that's concerned. And under Indiana law, where you're at is you're not able to recover the costs unless your governing documents provide for the recovery of costs and enforcement, right? So if your governing documents, and I actually have a community I work with that has about 2,500 homes, and they clearly can't amend anything because they have to get 3/4 of their membership to agree to amend, and getting 1,800 people to agree on anything is pretty insane. But as far as their declarant, their builder, as Debbie was stating, failed to include that recovery provision within their enforcement. They have every ability to enforce their governing documents. They can't recover anything for it. So all of those costs are borne by the homeowners association, hence borne by the homeowners, right? Because that's who's paying the bills. In the event that you can recover under your governing documents, you can only recover from the point in time of filing the complaint on. So the initial letter that's sent by our office or another office, the meetings that potentially occur, things like that, the legislatures has called that the cost of doing business, right? So you're not able to recover those costs. Hence why uniform enforcement is a bit difficult. That's where your business judgment rule comes into play. And the business judgment rule is basically what provides homeowners association boards immunity under the Indiana Nonprofit Corporations Act. And what that states is that any reasonable person in your position, meaning another reasonable board member, having done the due diligence and things like that, would make that same decision, right? You're enforcing against a mailbox that has the wrong font on it. Are you going to spend $10,000 of association money? The association would, the I'm sure the courts would probably at that point agree that they would say, you know what, that might not be the best business decision you could make to spend $10,000 of your association's money. Now, again, there's wide leeway there because of the fact that it's a reasonableness standard. So that's kind of goes back to that enforcement. As far as the architectural standards and things like that, as long as they don't contradict your governing documents, right? Because the hierarchy of the documents are the Declaration of Covenants, your Articles of Incorporation, your bylaws, and then any rules or guidelines. So if one of the above is contradictory to one of the below, clearly the one above will control. Let's say your guidelines say you can have 6-foot fences, but your governing documents, your covenants specifically say 4-foot. Well, you can only have 4-foot. I don't care what your CCR, what your ACR, your committee says. Well, we like a 6-foot fence. I don't care. You're not able to have to approve one in the community because that is something that goes against. The only time you can do so, and this jumps into the fair housing implications. So if you have somebody that is requesting what's called a reasonable accommodation for a disability or something to the effect, the example I use is I had one come up last month, I want to say, where somebody said they had an autistic child. They lived near a pretty busy road, and they provided medical documentation saying that they needed a higher than normal fence because that child needed a place to play with a little bit more of sensory deprivation. The association was able to provide a waiver to provide a higher than fence that would have been allowed normally by their CCRs to accommodate that. They weren't saying, hey, yeah, you can create this 9-10 foot fence, but you can put a 6-foot fence instead of a 4-foot fence. That is something you have to consider when you're when you're dealing with the enforcement, when you're dealing with approvals. You have to worry about the Fair Housing Act. Normally, what we would say is that if there's a fight between neighbors, right? Hey, my neighbor hates me and keeps ripping out my flowers. Well, it's because they're putting it on my property line. At that point, what we usually say, it's a neighbor versus neighbor dispute. Stay the heck out of it. It doesn't involve the association. Unless they're now hurling insults back and forth that are discriminatory in nature and deal with a protected class. So somebody's an African American, somebody's Hispanic, whatever it would be, and they're starting to hurl racial epithets back and forth. or something to that effect, then the association has the requirement under the joint statement from the from HUD and DOJ from 2016. They have to step in. You have to step in and do something, and that involves enforcement. And what you can do is you can basically enforce against both parties. Obviously, I'm not going to get into the weeds there, but fair housing is a huge consideration. If you have any questions whatsoever, or you have an inkling that a fair housing issue is involved, please contact your property manager and or legal counsel, because of the fact that these things get expensive quick. They can be filed in federal court instead of regular court, and nobody wants to go to federal court. So just be very careful, and they can drag on forever. So we need to make sure that those are handled correctly. As far as collections are a little different. Late fees are something that are not fines under Indiana law, so late fees can be done, but a lot of that is going to be dependent on the governing documents, right? What they say. If you're working with KMC, TJ and Colton are incredible. We work with them all the time, and they help us out so much when it comes to keeping ledgers, keeping delinquency policy resolutions, things like that. As far as that is concerned, obviously late fees can be put on there. There's notices that are put forth. Once it's turned over to our office, we have to send a violation letter pursuant to the Fair Debt Collection Practices Act. And then there's 30 days of a time involved for disputing. If there's a dispute, we can try to work it out. Otherwise, if that continues to occur, we can then take them to court to be able to try to collect those things, or we can put a lien on depending on how much the amount has ballooned to. And if we can get a judgment, that constitutes a lien on the property as well, and then those can technically be foreclosed upon. Foreclosure is a scary and very time-consuming process. I'm not going to get into the weeds here because we only have so much time. As far as voting is concerned, we talked a little bit about it. Voting has to be done pursuant to your governing documents. If you don't have electronic voting provision, it's very simple to usually amend your bylaws to include that. We would ask that you do that or look into that, because it can make things far easier for you. Mail-in ballots are able to be used in lieu of in-person ballots for, let's say, covenant amendments, things like that, as opposed to having to hold a meeting where it's one shot, one kill to get everybody there. You can you can use mail-in ballots for voting at meetings, like annual meetings. You can use proxies. Those are not ballots. Proxies are not ballots. Please understand that. They are the ability to hand somebody your right to vote. They still have to coincide with a ballot. So there's a lot of nuances involved with these things as far as that's concerned. And I know there's going to be a lot of questions. So if there's any questions, and I just threw a lot at people, so I have no problem clarifying.
I think the questions are more on just other stuff that you've got coming up at this point. So I think we're doing good on that.
Okay.
I have a question about a meeting without a meeting, and then I have a question on updating documents. So we will get to those.
Okay, thank you for everybody staying in with us. So bylaws are things the board can amend. They are usually board terms, quorum, annual meeting dates, and Jake's going to talk about the other ones that are available. CCRs require owner approval. And the community he mentioned that has 1,800 that have to say yes, the likelihood of getting it is often not worth the money that it takes to do amendment. Often you need it done, but it's so hard to get people to respond, even though they want it, and they might say in the street, oh, I can't wait till they get that amendment in, then they don't vote. So it's very time consuming. It requires the board to do emails, mails, knock on doors, continue to do it multiple times. And it's just really hard to get it done unless you're really committed, because it can cost at least $1,000 or more. And then common things that are done under bylaws and CSRs, like the rental amendment right now is a hot spot and has been for several years. You'll see that more cities like Fishers and Carmel just did, that they're setting out that CCR type limit for you. And that'll be interesting to see how that actually rolls out, and if there's going to be any challenges before those actually implement. The other common one that I see is maintenance checklist. It's really informal, but it's very helpful if you use it based on your annual documents. And then you can do online common questions that he mentioned that you could do through the resolution. I kind of went all over the place on this one, so some of that more will be mentioned in a couple other slides.
So Jake, we did have a question, and it kind of goes towards this. It says, when and why should covenants and bylaws be reviewed by the HOA legal rep for updating and refreshing? Their documents are 40 plus years old and have only had a few amendments.
So
Is there a
in the
rule of
normal course
thumb?
of things, sorry, go ahead, Dan.
No, is there a rule of thumb for something like that?
So the rule of thumb really is that 40 years is far too long. What you see is what you want to do, the rule of thumb really is if you have declarant language in your governing documents and you're not a brand new community, you've already been turned over, right? Like let's say you have something that says declarant has rights to this or that, or you can't charge them dues, and that's been from like 1985. We can review and update those as far as to bring those into this century, right? We want to make sure that we're cleansing the documents of any builder language to lose the confusion there. In the event that obviously it's been far turned over. Rule of thumb, I would say every 10 years you kind of want to give it a once over at least. The biggest thing we see is it's usually a provision by provision. If you have multiple provisions in your governing documents that you believe to be either out of date or they don't work right, they're just clunky, right? Then you kind of want to do it. You want to look at a major overhaul. I would say if it's 5 or more provisions, look to amend and restate your documents, meaning that you're going to change multiple ones. It's better to not have to have a vote on 5 separate sections when you can revamp your governing documents. If you have one section, like a parking section, that you guys want to change or something to that effect, you're probably going to be able to get one section through a heck of a lot easier than you're able to get, a whole giant document because you're going to have more opposition usually. It's just more surface area for people to attack, right? That's that. So that's what I would say as far as the amendment provision. And one thing I want to make sure of that I state is that and Debbie touched on this, bylaws, they normally can be amended by your boards unilaterally, but it's very document specific. Some documents, again, not ones we've drafted, would still basically mirror the same the same amendment provisions as the declaration. There's many times where it's the bylaws require a member vote too, and we look at it and like, what the heck are you doing, right? Then it's impossible to get this thing done, especially if you have something that says, again, 75% or higher. That's one thing you want to consider but if you can amend your bylaws by yourselves, as far as the board can, which again is the vast majority of them, look to doing that to make things a little easier as far as like electronic rulemaking is a huge one, right? As far as policies and rules, the association has to have that ability to be able to do that, right? You can't just say, well, we're going to have a no parking rule. Do you have the authority to do that under your governing documents? Well, no, then that doesn't matter. That's not a valid rule that you can enforce. You don't have that ability to do it. But we put a policy in place. I don't care. I've had that challenged, and the judge will rule the other way. So you want to make sure you provide that ability. So you're not only just putting rules in place, you're promulgating rules for the common areas, but also for the lots in general, right? And the association overall. So those are big issues that, again, if you have certain provisions that you're stuck on, contact your legal counsel. We can work with you on that. And then we can provide basically details on what language should be used, what language shouldn't be used.
What about if you're I have a question here from Fred? If your declaration is grandfathered prior to 1990, will seeking amendments cause jeopardy of losing your declaration and then have to fall under Indiana statutes?
No. So that's a great question. So what you have is a situation where if you go to our website, you can actually look at under the resources tab. We have it color coded to what is mandatory and what's non-mandatory from the 2009 HOA Act, right? So mandatory provisions, the grievance resolution procedure, and it'll say basically whether or not it's mandatory after 2009, prior to, right? So things like that are the amendment percentage, right? Some of them have, if they're from like 1950, have 95%. Well, in 2009, the state legislature said that 75% is the highest that anybody can have, right? So what that did is that it made that mandatory all the way back. If you're amending, you're not going to be in jeopardy of, unless you specifically provide in your governing documents that these are specifically towards the the 2009 HOA Act, which again, we won't put that in there if you don't want. You're not in jeopardy of losing that grandfather status.
Thank you.
Yeah. So let's talk about the amendment process for a second, as far as this is concerned. So our role in the amendment process is, again, to control the language, to help you guys out, to determine what the best language is, what's legally able and out there for you. As far as the amendment ballot and reporting, as far as that's concerned, so what we will normally say is, in lieu of having to have a meeting where you get like the example I used, hey, we're gonna have a meeting on September 18th where 1,800 people have to come, at least 1,800 people, and they all have to vote yes, right? Which is about as impossible. What we'll say is, we will say, do it pursuant to the Nonprofit Act in a mail-in ballot form. Because what that allows you to do is allows you to set timelines. You can set a date certain to say, okay, we're going to send out here and we're going to provide 90 days to our homeowners to submit their ballots back with their votes. What that allows you to do is that, one, it allows you to collect the votes as they're coming in, so you can in real time see that, fundraising thermometer rise as to, we need this threshold of yeses. We have 65% with 3 weeks to go. We know that, these 10 people, that we need 10 more votes. These 10 people have not voted yet. Let's go canvass and knock on their door and say, hey, have you voted? Can you, why are you considering voting for us? You have every ability to campaign. You have every ability to canvass. Please keep in mind, people can campaign and canvass against you. If they don't like a rental amendment, they can say, hey, we don't like that. This is why. They have every ability to go against you, as long as they're not making personal attacks and, false statements. They can do exactly what I'm talking about, right? Campaigning. So recommended timelines, I would say, would be between 60 and 90 days for a vote. Thanks.
Great, thanks, Jake. We're running a little over because we have so much to say, and Jake has had some great value to his suggestions. One thing I really want to go over is resolutions. Resolutions are necessary because owners that move in need to know stuff that happened in the past. You don't necessarily have to record it, but I always encourage it to be done. One that's been the hot spot in the last year or two is having heaters or grills on decks or within 10 feet of a building. We have seen where insurance has been canceled because they just see one grill. So it's important to follow up on that so you can put the resolution in place, and then it goes to putting in the enforcement. Maintenance checklist, people should use it, but always have an attorney review it to make sure it complies with the HOA documents. And if possible, you can record it, because you can always change it later, because it'd be done as somewhat as a board member. Right now, Jake, I think we're going to move on to the next topic because we're running a little late.
Yeah,
That's
no
okay.
problem.
We want to leave time for questions.
Yeah.
Okay, policies are really just things that the board can do as far as part of their powers. Jake mentioned having their ability to do things. Common things are pool hours, setting up reservations, or doing an event and you have to give notice. Sometimes it's the public streets. In some areas, the CCR says you have to do, they can't put it on the street. Well, when it comes to public streets, that is up to the city to enforce. Another one is fireworks. In communities that have a lot of trees, that can be very dangerous to allow it. Even though like Carmel allows you to do it at certain hours, that doesn't mean it should be done for your community.
I would say
To
I,
Jake, you
the
didn't-
only thing I'll say, I'll jump in real quick
Yeah.
and just to piggyback on the last two issues of the resolutions and policies. Debbie's completely right, right? It depends on what the governing document, it depends on the association. So, and you want to make sure before you enact any type of rule or policy, one, you have the ability under the governing documents to do so. Two, they don't contradict your declaration specifically, right? So you can't do anything. If they're silent, then by all means. And if you have any questions, make sure you're contacting your legal counsel. Recording is always a fantastic thing because it puts everybody on notice. So.
Okay, now I want to give time for more questions, and Jake, if you have any other items that you want to cover, that would be great. Jan, it's for you.
One thing I would like to say is as talking for Kirkpatrick Management, our managers are very good at a lot of different things, but they're not lawyers. They just don't, even if our past, we have associations that did it this way, did it that way. It's really, in the scheme of things, pretty inexpensive just to drop a line or have your manager drop a line to the attorneys and just ask them. I mean, it's just it's a couple $100. It keeps everybody. It's instead of saying, hey, Debbie says this, or Joe Jackson, our board president, says this. It carries a little more weight. It is something that makes you speak a little more confidently. Say, we ran this by our attorneys, and they're saying that yes, even though the city, even though our declarations say one thing, the city says this, the city trumps what we're saying. So just those kind of things. So every once in a while, it really is it's not a bad idea to ask your attorney just for a question. If it gets really heavy, then they'll quote some prices for you if it's an amendment change or things like that. But a lot of times it's not bad to have just your attorneys out there. I know Eads Marine Pew has a retainage program where you can sign up to be part of their they have what's it called, Jacob? I'm sorry about
It's
that.
called the annual service program, and part of it is when you're talking about is a free 15-minute weekly phone call if you're
Yeah.
part of it. So to ask that question, and to Dan's point, if you ever need an illegal opinion, a good point is most of the time we'll provide that in writing, and then the board can keep that in their back pocket in the event that some similar issue comes up. They can refer back to the legal opinion, the written legal opinion that says, oh no, hey, the tree maintenance or whatever, we got an opinion on it, so we now know how to handle it if the issue comes in the future. So it's always a
Yes.
good idea. And Dan's right. The costs are usually pretty minimal. It's the old stitch in time saves 9, right? So.
Okay, I do have a couple questions. Fred asked, Jacob, was that explaining having a meeting without a meeting, nonprofit statute regs, emails to director, unanimous approval of a motion, otherwise no motion pass. I think he sounds like he's speaking directly to you, so I think you probably know what he's talking about a little more than I do.
Yeah, no, I get what you're saying. So basically, it's saying like, let's say you guys, as a board, are trying to determine, we're going to put up new basketball goals at the community park, right? That's an example of what just happened. You see emails going back and forth from 5 directors outside of a meeting, right? They don't actually have a board meeting, and they're saying, hey, yeah, let's go ahead with this. Okay, let's go ahead with this. And you have 4 out of 5 directors that agree, right? Well, because you're not within a meeting and you didn't clarify at the prior meeting that we're going to hold this vote in the interim, no official action can be taken until it's unanimous, right? So if it's a 3-2, the majority does not rule there, right? If it's 5 out of 5, say, yeah, let's move forward with it. Then you can take an official action. And at the next board meeting, what you'll do is you'll say, hey, 5 out of 5 of us agreed to put up basketball goals via this email chain from September 16th. We're going to ratify that decision. So that's how that is set up, as far as it's to try to make sure that things are done at a meeting that should be done at a meeting. If you don't have a unanimous vote, right, where you're all not coming together, you need to be able to discuss it. That was the purpose of that. But if you guys have something that's super easy that you guys all agree on, the legislature is basically saying, why spend the time talking about it at a meeting when all you got to do is, great, you had your vote. We'll just make sure we note it in the next meeting minutes that, hey, we had that vote already and we all agreed. So hopefully that
Okay.
answers the question.
One of the questions, I think this probably goes back to call your attorneys. What do we do if a homeowner refuses to remove a heater off of their balcony? And as Kirkpatrick will tell you, we can only write so many letters. This is actually a safety hazard, and that would be, we would probably recommend it came from an attorney, and you would probably do it certified at that point, I would imagine. Or
Yeah, I would agree with you. And there's with the grievance resolution procedure that we talked about, not to get too into this in the weeds, if there's something that's an emergent situation, affects health or human safety, which potentially that could, we can jump to the head of the line. We don't have to send the letters. We can literally file a lawsuit and say that it's an exempt claim because it's an emergent situation. So something to that effect. Again, it's dependent on the facts of the issue. That and don't be afraid as a board to call code enforcement. Don't be afraid to not only use, you can use your legal options, but use the options that are free to you as well, right? If you have an animal running free, right, that you believe a scary dog is out there, yeah, that homeowner should be kept, should be punished for or put in line for keeping his animal off leash. But call animal control, right? They're there for you too, and those don't cost you anything to call, the authorities or the civil services.
I
So,
called animal control this week. Yeah, they're about the nicest people in the world too, half the time too. So they got a crummy job, but they got great customer service. One last question. I think Dennis has a question, and I think it's more clarification. He says, "Did I hear correctly? If quorum is not achieved at annual meeting, the budget and the board continues into the new year."
yes. So if you don't have a situation where you can set a second meeting or something to that effect, and you don't get quorum, you don't meet quorum, the board continues as currently constructed, and basically you're reusing the same budget. So the 2025 budget, you don't have quorum at 2025 annual meeting, that would be your now 2026 budget.
Okay.
If
All
it
right. Any
has to
last
get a
word?
homeowner approval, that's what, please remember that. If it has to get homeowner approval, if the board can approve the budget, that's something they can do in a board meeting.
Yes.
They just have to provide it to the homeowners.
Debbie or Jake, any last words or anything you can think of? Okay, I have been asked for Jake's contact information tomorrow, or probably more like Monday. You guys know me by now. We will send out a copy of this recording, and we will have contact information for both Debbie and Jake so that you can get a hold of them email wise. We also have a PDF of this presentation, and probably a link to the Eads Murray and Pugh website. They've got great, just regular old information as far as the documents. They have the HOA law. What's in that book that you've got? They got a, what's the book there, Jake? I can't remember. You probably have it in
Oh,
front.
if the retainer practices, it's the common practices and stuff. We wrote a book on, if you're a retainer member, every board gets a free copy. So
Yep. So, and then you can also talk to him about the retainage policy or program. It's something that quite a few of our associations have if they've got some different things going on. I do want to say that if there is questions, Irene, I didn't see your hand was raised. I'm sorry, Irene Williams has a raised hand real quick. Client retention program, the Kelly Quigley, she is my wife, so the name does sound familiar. She is in charge of our retention program, or basically client relations. And what that is basically you need to, if there's a board member and you have questions and you're like, this isn't working, we need to tweak this, or there's some questions that aren't being answered, you can call me, you can call Kelly. But a lot of you have been reached out. If you're board presidents, she reaches out to all board presidents a couple, 3 or 4 times a year. She's not trying to sell you anything. She's just trying to see how things are going. It's a program where we started a couple years ago just to check in with everybody and see how things are going. A lot of times we can do a little quick tweak, or, hey, you know what? Ryan's doing a great job. Tell him to keep it up, things like that. Irene here real quick. I think if your hand is still raised, I'm gonna try and get it so you can ask a question. I do not see my alphabet. What was Irene's last name? Williams. I am sorry. I think I lost Irene. So, oh, there she is. Hold on. She got a hand. Allow Irene to talk. Go ahead, Irene. Can you, Irene? I think I can hear you.
I already sent the question in and it was answered already. It was about,
Okay, great. Okay, sorry about that.
yeah, that's okay.
I'm trying to find that out. I had something over my thing. Thank you all for your time. Appreciate everybody's work here today, or at least sitting through all of this. And I think we all learned something. If you have more questions, give us a call. And as always, we'll have another one here in a couple months on annual meetings, just to get everybody brushed up and ready to go. Appreciate your time. Thank you all.